Alex here with a video on legal nuts and bolts. In this video, I'm going to cover the notice of change of address, why it's so it's simple to file, and it's also so important to do it, because if you don't, the consequences can be so bad. So the best way I think I can explain what this is and why it's important is to kind of contrast the way service of process works, between, I guess you could say, two rules. I'm sure it's the same in all the other states. I don't know if it's the same number. In Nevada, it's NRCP 4 and NRCP 5. Those are the two different rules. It may be, under a different heading in your state or under a different rule, or it may even be a statute. Check into that yourself, please. Don't just go off of what I'm saying. If you're in Nevada, even check after me, because the rules actually could change. You might see this video and then 2 years later the rules have changed. But anyway, the best way I can explain this is by contrasting NRCP 4 and NRCP 5. So NRCP 4 covers the service of the initial summons and complaint. If you've seen anything like Pineapple Express, you might imagine how this works. Or if you've had to represent yourself, you probably have personally gone through this. You have to find somebody else over the age of 18 to serve your opponent. It can't be you. It could be like a sheriff, the sheriff's deputy. It could be a process server, which would be like a company or like a business. Sometimes it's just like a one-man business or a one-woman business. Or it could even be a friend. You could have like a friend do it for you. They have to physically find your ex and give them the initial summons and complaint. That's NRCP 4. It talks all about it. Once you've served that initial summons and complaint, the rules literally change. So NRCP 4 is done, NRCP 5 takes over. NRCP 5 is completely different. You can serve anything else under NRCP 5. Motions, notices, whatever it is. Anything else you want to file in your child custody case, you can do it under NRCP 5. In fact, you have to. That's what controls going forward. And you can do it yourself. You no longer have to bother somebody else to do it for you. And what I'm getting at is you can also mail it. So what happens if you or your opponent moves and you don't update your address with the court? Yes, this can happen. Your opponent can mail a motion to modify something. If it's a child custody case, just imagine a motion to modify physical custody can be filed and mailed to your previous address where you no longer live. You're not going to get that unless you're lucky and it's still forwarding to you. If you don't get that, the Supreme Court of Nevada has published a few cases where they basically say, too bad, so sad. NRCP 5 says all they got to do is mail it to the last address known. You've moved. You didn't tell us where you moved to. Too bad. And this happened to my ex, actually. She had an attorney through most of the case, so, I was serving her attorney, but towards the end of the case, she didn't have one. And she didn't file a notice of change of address, and in fact, she actually deliberately refused to do that. She deliberately refused to file a notice of change of address. And so when I filed a motion to modify legal custody, it went to her old P.O. box, and it bounced back. And the court didn't care that it bounced back, and the court didn't care whether or not she got it. The court just checked, did Mr. Falcone mail it to her last address? He did. We're moving forward. And that's what happened. The court granted me a modification of legal custody without her even filing an opposition, without even setting a hearing. This can happen to you. So please take it absolutely seriously. If you move, file a notice of change of address and let the court know of your new address, because then if they send it to your old address, you can point to that and say, I filed a change of address, you sent it to the wrong address. And the court will actually check it too. They should check, and they'll probably not grant whatever your ex is trying to get, and they'll probably order your opponent, your ex, your opponent, whatever. They'll order them probably to look at the notice of change of address and resend that, whatever they filed, resend it to that address instead. Just one footnote I want to add here. I've seen that some states actually cover weird circumstances, like in California, I've read that, I haven't verified this, but I've read, so don't take my word for it. I've read that if you file a post-judgment motion, so a motion after the case is closed, after the judgment has been entered, if you file a post-judgment motion in a child custody action or a divorce, the person filing it has to go ahead and track their opponent down again and serve them personally. I've seen that. Nevada doesn't have that, and I'm not sure how many, if many other states do. So I do want to let people know that you may be in a state where that's kind of taken care of, where your opponent will have to find out where you've moved to and serve you. But don't risk it. Really, it's what's at stake: your custody of your kids and I don't know what else is going on in your court case, but there's too much at stake to mess around with that, or play games with it. Like some people play games, other people just don't know. They just don't check the rules. You know, they get swept up in life. It's, you know, things are bad, busy, you're working, and you just don't remember. I wanted to do this video just to let people know how important it is to file the notice of change of address when they move. So with that, I'll see you guys next time.